and there is an interesting new provision in it having to do with a data protection officer. So this person is going to need to be highly connected, highly effective, and highly accessible. Today, we're going to talk a little bit about the history of the GDPR, the qualities you need to be looking for in the data protection officer because of what is going to be required of that DPO by the GDPR. We'll also touch base on how EXIN can help if needed. My name is Quinn Shamblin. I'm the Chief Examiner for EXIN's Privacy and Data Protection Portfolio. My contact information is on the screen, so feel free to reach out to me if you've got any questions. You'll note that nowhere on this slide does it say attorney. I'm not a lawyer. I've dealt with law, regulatory compliance, interpretation for most of my career, but there are 99 different articles inside of GDPR. You're going to need your own attorney to help you determine how to interpret those particular regulations for your unique circumstance. And this presentation by no means replaces that. However, I can help you understand some of the questions you're going to need to be asking, particularly around this idea of a data protection officer. So the things we're going to be hitting. A little bit about trust, some context and a little history of the GDPR, the way the GDPR is designed with both a kind of a carrot and stick approach, and then we'll talk about the DPO and their responsibilities to the GDPR and to your company with respect to dealing with the GDPR and what kind of person you need to be looking for that position and how EXIN can help. First, let's talk a little bit about trust. David Horsager is the author of The Trust Edge, and he runs something called the Trust Institute. And according to some really interesting research conducted by David, a lack of trust is one of your biggest business expenses, if not the biggest business expense. Think about business for a moment. Think about how you might be able to conduct business if there was a strong degree of trust. For years, for hundreds of years, for thousands of years, business was often conducted on a handshake. We were living in smaller communities. We knew the person down the street. We would get into business dealings with that person just because we knew who they are. We knew we could trust them. We knew we could go talk to them if something was not going the way it was supposed to go. And in that world, a lot of business was conducted based on a handshake. And as the world has gotten more complex and more challenging, we have had to figure out ways to try to enforce trust. And that's where laws and attorneys and contracts have come into play. But when you have a strong degree of trust between you and another person, a lot of positive things increase and a lot of negative things decrease. So loyalty and creativity and productivity, all of these kinds of things are increased when you have a trusted environment. When you don't have a trusted environment, you need to have contracts. You need to have attorneys, and that's pretty much going to slow some stuff down, as we're all familiar. So if we did not have a world in which there was a lack of trust between customers and businesses, between businesses and other businesses, between countries, we may not need regulations, but unfortunately that's not the world we live in, and we do need regulations. We do need laws to try to govern this and try to establish those structures and expectations about what levels of trust are required in order to do certain kinds of business. So how is trust built? How is trust created and maintained? There's really only one way. In order to build trust, you must make and keep commitments. You tell somebody you're going to do something, you tell them what you're going to do, and you do it. Every time you do that, you're building that trust with that person. Before we continue, I should mention that we have a handout for this presentation. It includes all the slides. It also includes all the notes and references used to create this presentation. So for those of you who might be furiously screenshotting or writing down what I'm saying, we've done that for you. I'm not saying don't do that if that's how you learn. That's great. But if you'd like to just sort of listen and not have to worry about feverishly doing those things, we will hand that stuff out to you at the end of this presentation, so you can relax if that's your preference. I will, for example, be including the links to the Trust Edge if you wanted to find out more about what that is and find out more about David Horsager and his work. Let's talk about a trust situation. There was a data breach that Uber experienced in 2016. Now, we all heard about this just last month in 2017. Now, what happened, if you hadn't been paying attention to that particular side of the world and dug into what occurred there? The developers for Uber use GitHub to store code related to their services, and someone accidentally or without thinking about it, one of the two, uploaded a document which included the username and password for the administrative account for their Amazon S3 buckets. So this is basically where they're storing all of their data. They simply uploaded their username and password to GitHub where other people could find it. And this is not a particularly uncommon error. There's been 5 examples of this exact same error in November of 2017 alone, and we're seeing a couple more come in December. This is happening a lot. There's a certain level of, I would say, best practices, if not just fundamentals, that people aren't thinking through while they're doing all of this development work and they're trying to move toward a cloud-first environment or a cloud-first strategy. And these kinds of errors are just coming to light more and more often. It's one of those reasons why it's really important to have experts in the field of information security involved in your development process and have someone be watching out for these kinds of common issues. And it happened to Uber. Now, it impacted 50 million customers and 7 million drivers, information about 7 million drivers. For customers, Uber tells us that the data included name, address, phone number, and email. For the drivers, they tell us that it included all that same information, but also the driver's license number and the car license plate. So some people are asking the question, well, this seems like information that's semi-public. Should we be concerned about this kind of a data breach? Well, there's 2 things I'd like to talk about there. Number 1, any time that information about you and 50 million of your closest friends is collected together and made easily available to people who have, let's say, ill intent, you need to be concerned. Because even though the data seems like it might be on the surface relatively public, the kind of thing you just tell somebody if they asked you, in fact, it is also very powerful when you're thinking about what we call pretexting attacks or pretending to be you. In a world where somebody can call or get online and try to impersonate another person and get services or try to scam money or get into somebody's account, any information about you can be used and collected with other information in order to more effectively do that. Fraud is a very big issue in the financial and insurance industries. And one of the ways that it occurs is that people call the call center of an insurance company or a bank, and they say, I lost my credit card, I lost my HSA card, I'm traveling internationally, I'm going to be going and staying with my uncle for 3 weeks, and I may have some medical emergencies. I need you to send me a new credit card to this alternative address because I'm not going to be at my regular home address. Oh no, I'm not going to be able to get online either because my phone doesn't have connection in this other country. So I can call, I can talk to you, but I can't get online and confirm things on the internet. So can you please just send me that card? And if the person if the fraudster is convincing enough, the call center employee might be tricked into believing that they are talking to the real person, and they may indeed send that credit card off. This kind of fraud is relatively common. So if you have somebody's address, name, phone number, email address You can start to pretext. You can start to pretend to be who they are. When you start adding somebody's driver's license numbers and car license plate numbers, now you're getting into that territory where you may be having the answers to some questions that allow somebody to do a password reset. So, for example, those knowledge-based authentication questions where somebody asks you what your mother's middle name was and what the mascot of your elementary school's baseball team was or something like that. Sometimes they ask you what's your driver's license number. And these kinds of things can be used and can be built and aggregated with other information to cause havoc. And so no data breach should be looked at like, that's not a big deal. If it has your information on it, you need to be concerned. The second point is that it was a data breach. It was not the way things should have been. Information was entrusted to a company. The company failed in their duty to live up to that trust. And it goes deeper than that. When we start talking about trust, and this is the reason I started the conversation off this way, recall that this event occurred in 2016. It's 2017. Why didn't we hear about it back then? When there are regulations in place now that say if you lose certain kinds of information, you need to tell people about it. Well, Uber decided to try to hide it. They paid off the hackers to say, just don't mention this, we'll go get it fixed. And they tried to pretend that nothing had happened. And here's where that trust thing really comes together. They had regulatory responsibilities. They chose to not follow those regulatory responsibilities and instead tried to hide the information. So when they tell me that my customer data was only name, address, phone number, and email, and I happen to know that you have to give them a credit card number in order to set up an account with them, do I trust that that is indeed all that was lost? Or might that credit card have been in there as well? And because they chose to try to hide this thing in the first place, they're trying to hide that as well. I don't know the answer to that question, but it's that concern. It's that trust element that gets violated when a company doesn't do what they're supposed to do. Whether it's regulatory or whether it's simply what's right to do with somebody else's data, these kinds of issues start to make a hit on that consumer confidence. And consumer confidence is a big deal in business, as you are all very much aware. There's a venture capitalist who runs out of New York City who's been quoted as saying this: the companies that will do the best job, on managing a user's privacy will ultimately be the most successful. So when this person is looking to try to put millions or billions of dollars into a business to allow that business to grow, he looks for what that company does to ensure the privacy of that company's customer data. He feels that those companies are more to be trusted, and therefore he can trust them with more money in order to grow. So it's all these connections that help us understand more about how a company works because of how they choose to treat our information. And that's where GDPR really kind of comes together. And it's so there's a phrase that we use in the United States. It's printed on all of our money, e pluribus unum, and it basically means out of many, one. So the United States, we created a country out of many things that could have been countries on their own. But the idea, I think, is powerful. The idea of coming together, making one strong thing, even where there's certain kinds of differences, there's certain things that you don't want to have different. And that is one of the things that GDPR tries to help us do. So let's take a step back and talk about the predecessor for GDPR, which was the Data Protection Directive, the DPD. This was a 1995 initiative, but it was a directive, not a law, not a regulation. So because it was a directive, it's not something you get to ignore. You still need to do it. But each member country needed to go create their own law and then create their own precedents and their own interpretations of that law in order to establish compliance with the Data Protection Directive. So the UK had the DPA, Germany had the BDSG, France had the LIL, and they were all operating within the spirit of the Data Protection Directive, but they were all slightly different. So it was not possible to be compliant with the data regulation in your own country and also be fully compliant with the data protection directive offspring from other countries. So if you're ever familiar with how credit card security regulations worked prior to the PCI, payment card industry's data security standard, PCI DSS, it was kind of chaos. You couldn't be compliant with the contract for Amazon, excuse me, for Amex, and also be compliant with MasterCard. You couldn't be compliant with MasterCard and also be compliant with Visa. And so the companies all got together and said, okay, this is kind of a problem for us. People can't be compliant with any of our contracts, so let's get together and make one of them. And that is what has now also happened with the GDPR. It's the idea is that the GDPR is a regulation. It is already a law. So member countries don't need to go create their own laws. They don't need to create their own court histories, their own precedents, their own interpretations of that law. There's one law. It's already going to be law for everyone, so everyone needs to follow that. And all of the legal work, all of the attorney arguments and the court precedents and all that will be established across the whole system for people to leverage and figure out how to interpret it as things move forward. So this brings all members of the European Union up to the same level of requirement. In some cases, some things have been relaxed, so some could argue down to the same level of requirements in some cases. But there are some huge benefits to the idea that everyone is on that same level playing field. And that is where one of the real strengths of the GDPR becomes apparent. One of the primary goals is to actually make business easier. Eventually. So yeah, it's going to be a challenge. The next few years are going to be rough for a lot of people in trying to figure out how to get into compliance as we see what the regulators are going to do in interpreting GDPR and how they're going to apply it, how they're going to conduct the enforcement arm. There's going to be challenges there. But on the other side of that is an increase in trust. GDPR requires that privacy and security be built in by design and by default. And that's a huge step forward for consumer trust and therefore potential growth for all sorts of industries. But it's also about increased portability. It's about the free movement, or relatively free movement of data within the system. When everybody is required to be at the same level of security, data can be moved across international boundaries or corporate boundaries much more easily. You don't have to sit down with a team of attorneys and go for months and months trying to figure out, okay, what elements are we compliant with? What elements aren't we compliant with? What do we need to do in order to be able to share data with you? Everybody should be on that same level playing field. And consequently, those conversations can be much shorter and much more constructive. So I see an opportunity here in the GDPR. We can look at what we are doing, how we are interacting with our partners, and say, okay, where can we standardize our services, standardize our processes so that things are more streamlined, there's greater efficiencies in the system, we can lower total cost while maintaining that appropriate level of confidence by our consumers that we need to have. So I'm not going to get heavily into all of the requirements of the GDPR. I do want to make sure that everybody's on the same page. I'm going to do a few highlights of important points that come out of the requirements of GDPR just to make sure we're there. And then I'll shift over to specifically talk about the data protection officer. But it's important to understand what the GDPR is going to require in order for you to wrap your mind around what the DPO is going to need to do. So we're going to take a minute and talk through some of these details. So first of all, there's 6 core principles of the GDPR. You can find these in Article 5, and it's actually not too bad of reading. I would suggest that people take a few minutes and actually read a couple of the core provisions of GDPR because they will really help you with that context. So first off, lawfulness, fairness, and transparency. You need to tell your data subject what data processing is going to be done. I'm going to be collecting this kind of data. I'm going to be doing this with it. You also need to do what you say you're going to do and no more. We've seen many, many times where a company puts a policy on their website that says we collect this information, but this policy is subject to change at any time with no notification. Well, GDPR makes that a little bit more challenging. If you are going to do something beyond what you had originally stated you were going to do with that person's data, under GDPR, you need to get further consent. One-time consent for using my data in perpetuity for any purpose you could possibly think of now or in the future is no longer how things can be written and run. Within GDPR, you need to tell them what you're going to do, and then if you're going to do something else, you need to ask them again. It's a pretty important point. So you're limited to specific, explicit, and legitimate purposes. That's a quote from GDPR. It also needs to be the minimum amount of data required to do the thing that you said you were going to do. So if you are Uber and you need to be able to send a driver to the location of the person who needs to be picked up. Obviously, you need to collect information about that person's name, the physical location, whether you do it via geolocation or whether you have them enter an address. There's information that you need in order to provide that job and do the thing that you're supposed to do. But there's no reason whatsoever why you need somebody's health information to do that job. So you are prohibited from collecting that kind of information because it doesn't have anything to do with what it is, the services that you are providing. There's an accuracy provision. So whatever you keep as a company, the people who that data is about, so the data subject needs to be able to see what it is that you have and be able to reasonably update that information if required. There's limitations on storage. So many of us have built huge data storage systems that simply consume all the information on all of our servers and back it up in a consistent way every hour, every day, every week, something like that, so that we have disaster recovery capabilities. If this set of servers drops, I can go to my backups, I can restore all that information and continue on with my job. Well, many of those kinds of processing capabilities and backup capabilities do not include the idea of removing data from those backups. But under GDPR, and the right to be forgotten components of it, you need to be able to completely remove any information about a given person upon a legitimate request. And that includes whatever backup, disaster recovery, business continuity capabilities you might have. So one thing to be thinking about now and planning for now is what kind of things do we need to do in order to be able to comply with that kind of a requirement, because most of our systems aren't set up for that quite yet. And finally, there's this integrity and confidentiality. Data processors are required to handle data, and again, here's a quote, in a manner ensuring appropriate security of that personal data, including the protection against unlawful processing, accidental loss, destruction, or damage. Now, I work in the information security field, and information security is often accused of only caring about data confidentiality. You want passwords on everything and you want encryption on everything. We do. We want passwords on everything and encryption on everything, but not really. People often forget that security is bound within what we call the security triad, or the three legs of security. Confidentiality is certainly there, but so is integrity, and so is availability. So when we say that data, when data is being appropriately handled, the right people should be able to get access to it when they need it. That's what availability means. The data should be correct. That's what integrity means. And it should not be accessible to people who shouldn't have it. That's the confidentiality part. And people sometimes lose those integrity and availability pieces, but those are really, really important. When you start talking about privacy and you start talking about GDPR, people will start paying much more attention to that going forward, I believe. I believe most people are already familiar with this point, but it's really important. The law, the GDPR, is about data that belongs to EU citizens. There is nothing in the law that proscribes a geographical location or of the data or of that EU citizen. So if you are a company that's based in Africa and you have information about one of your employees who's living in China, but that employee is a citizen of Germany, you still need to follow GDPR because that citizen is a German citizen. And regardless of where you are and where they happen to be, you still have to treat their data in compliance with GDPR. So it's a very important point. It's going to have broad sweeping impacts across the globe. And that's why there's a lot of hype about it right now, because people need to be getting ready. All right, so let's take a look at this sentence. It's seemingly simple. Before you can collect special categories of data and drive your services from that data, you need the consent of the data subjects. Well, there's a bunch of stuff in here that people probably aren't going to agree on. So first off, special categories. This is actually defined pretty well. If you go look in Article 5, all sorts of information about a person, particularly any data that could uniquely identify a person, is included in this special categories of data. So PII, personally identifiable information, including any kind of social identity, is included. Data that could be used to identify a person even if only through statistical analysis. So if I know that this person is between the ages of 40 and 50 and has heart disease and is in the Netherlands and has blah, 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 additional qualities, might I be able to identify who that person was? If so, that data is covered by GDPR. Statistical analysis is part of this. This is very similar to a regulation called HIPAA in the United States, Health Insurance Portability and Accountability Act. It recognizes the idea that there's information about a person that is valuable, and if you can positively assign it to a person, that makes it more valuable. GDPR does exactly the same thing. Now, an interesting little twist is that internet cookies are explicitly included as identifiers in GDPR. They're going to have to be announced, explicitly announced and consented to, but they're on that list because they can be used to explicitly identify you, because they can identify which device connected for that service, excuse me. Another thing that's included, which people are having a lot of argument about right now, is the IP address. So from a technical perspective, IP addresses are not very good identifiers because the IP address that my computer is using right now could be being used by my neighbor in 30 seconds or next week or a month from now. IP addresses are assigned on a temporary basis to a given computer based on when they connect and some technical things about when they are renewed. So they are identifiers. An IP address combined with a timestamp, combined with the information from your internet provider who lists who had that IP at that time, can positively identify a person, which is why it's on the list. But because it is so subject to being manipulated, it is going to be subject to a lot of argument in the court. So we'll see where it ends up. But right now, it's on the list. So if you're collecting people's IP addresses for any reason, it's still part of this set of different data types. Next one, consent. Consent before data is collected. And it's explicitly opting in, not taking pains to opt out. So the days when you have somebody come into your site and put a bunch of information in, and then, oh, you don't want our newsletter on this, and this. You know, you don't want 15 newsletters coming in. Go in and undo those, uncheck those, because by default we're going to give them to you. That's not how this is intended to work. GDPR wants you to say, okay, come on in as a condition to using our service. We're going to be asking you for this and this and this kind of information. So if you don't want to give us this information, just go find a different service. And oh, by the way, here are the things that we can provide to you as parts of these service. Can you hear me?
Yeah, you're back again.
Okay, thank you. All right. And then finally, data subject. This one's interesting because of this distinction. A data subject is not limited by nationality or place of reference, but they must be an identified and identifiable natural person. So a corporation or other entity has no protections under GDPR. Your company does not have these privacy concerns in the same way that a consumer does. So it's an important element for you to be considering as you're trying to plan your responses, as you're trying to understand what's covered by GDPR and what is not. Some kinds of corporate data don't have the same protections, and they can still be requested, and you don't have shield in the GDPR against providing that information. So it's something to talk about with your attorney. Make sure you understand the scope of this. So this is what I mean by a complex sentence. Now, let's look at that other thing. I talked about the carrots, where eventually things should be a little easier because everybody will be on the same point. It's designed to build trust. Well, I think a lot of people are familiar with the stick side of GDPR because they tried to design it in such a way that people would pay attention. There are a lot of companies that have a really well understood track record of trying to ignore regulations where they can. Basically, I'm going to take the risk because if I get fined, the fine is only this amount, which I don't care about. I can pay that on a yearly basis, a monthly basis, and I'm not going to spend the money to become compliant with the regulation. I'm just going to spend the money if I get caught. Well, GDPR does not want that attitude to be part of the equation. So they created a series of fines associated with not being in compliant with various articles. And there's two different levels. They're trying to create this structure to be quote unquote effective, proportionate, and dissuasive. And those are really interesting terms, which talk about the philosophy behind how these things are structured. But when they say dissuasive, I see that. When you have higher rate penalties that have to do with privacy of information, and you have lower rate penalties, which are administrative fines related to non-compliance of internal things that you're supposed to be doing. They're both pretty substantial. Up to 4% of your global revenue or 20 million euros, whichever is greater. Up to 2% or 10 million euros, whichever is greater. These are some pretty big numbers. And for some companies, it could be quite painful. Now, I'm not going to go into what all of these articles are, what all the requirements are. There are plenty of resources out there that already cover this ad nauseum. But just so you have the list, it's in the presentation. It'll be in your handout. These are all of the articles that have the 4% penalty associated with them. And a couple to notice here are the transparency elements I talked about, the rights to see what has been collected about you, the right to correct that data, and the right to have it erased or forgotten. These are all elements in that 4% range, so pretty big. There's a link in the handout for this slide that provides you the source text for all of the EU laws in 24 different languages. And a couple of versions that are actually a little more easy to read. So there's some great resources here in the handout if you want to go read up on any of these things in more detail. But on the 2% range, the lower but still extremely impactful range, you also have a security of processing, notification obligations, both to regulators and to data subjects if the information is in somehow accessed or lost in a way that was not intended, and the requirement to have a data protection officer. So if you do not create a data protection officer role and sufficiently design that role to meet the requirements of GDPR, you can be fined for that. Now, I'm not a person who likes to preach doom and gloom and all sorts of a scare tactic kind of stuff, but it's important to note from a risk planning perspective that putting this role in place is a requirement of this regulation. So hopefully all of the, this splash of text that has hit you in the past couple of slides, I don't really like text, I like pictures. So here we go, I'm gonna go back to pictures. But hopefully all that text has convinced you that this is a complex situation. There's a lot here. It's a lot of important things that need to have high-level attention. And the GDPR recognizes that they require high-level attention, and that's why GDPR creates the data protection officer role. It's intended to help organizations with all of this stuff. And there are 3 articles related to the data protection officer. We're going to look at each of those in a degree of detail. What we're trying to get to is an understanding of what the responsibilities of data protection officer are and the kind of person that you need in that role. So first off, let's look at the designation of the data protection officer. In the handout, I include the text of these articles, the text straight from GDPR. They're not long, and they talk about a few important things. So number 1, you have to have it. The controller and the processor, so whoever's collecting the data and owns it, and the processor, if those are different companies, if it's outsourced, shall designate a data protection officer. That's non-optional. That's RFC 2119 wording. Where, and here's where things are going to get a little more confusing. So recall that whole complexity thing we did last time. This is also pretty complex. Where core activities consist of processing special categories of data on a large scale. Well, we've already talked about special categories. We know what that one means. It's any data revealing racial, ethnic origins, political opinions, religious, philosophical beliefs, trade union memberships, interestingly enough, the processing of genetic data or biometric data for for purposes of uniquely identifying a natural person, data concerning health, and I'm reading off a list here, or data concerning a natural person's sex life or sexual orientation. All of those things are on that list explicitly in GDPR of special categories of data. Now, core activities, that's another interesting question. What does core activities mean? This is not well defined in GDPR. This will be subject to a lot of debate in the courts and amongst attorneys. Right now, if you look at articles that attorneys are blogging or posting now talking about it, they are including things like, does my website collect behavior about a person who's visiting my website so that I can provide behavioral-based advertising to them? Do I have Google Analytics connected to this thing? Well, because your company has decided that getting that kind of activity information is in some way important to your business, you need to know what they're doing on the site so that you can better serve them. For example, that is considered a core activity according to the attorneys who are debating this topic. Now, it's not been defined and decided by the courts yet. We'll have to see how it plays out. But right now, they're debating that, yes, that would be considered to be a core activity. Now, here's the biggest challenging statement: large scale. That is not defined anywhere. Nobody knows what that means. Again, if you go look at blog posts, you look at articles being posted by attorneys who operate in regulation and EU law specifically, and I've included at least one link in the handout. There is little guidance on it, but people are highly suggesting that you approach this from the perspective of caution. And that if you collect, and in some articles even say any data about some other person that's not directly part of your company, that needs to be considered as being protected by GDPR. Now, I suspect the real answer is going to be heavily battled in the courts, and we'll eventually get some kind of numerical guidance. If it impacts X number of people, then it falls into this category and you need a data protection officer. Otherwise, you don't need one. You can get your information other ways. So that piece of the guidance is really unclear. But if your company is the kind that directly collects personally identifying information from all of your customers in order to provide services to those customers, you need to consider yourself part of this definition. If you're selling shoes and you don't need to know anything about a person other than let me have your credit card for a second so you can buy the set of shoes, that's great. If you are doing some kind of online thing where give me your name, your address, your phone number, I will do some processing for you and I'll give you this other information back, you're covered under this and you need to have a DPO. All right. A couple of things about the data protection officer. If you have a group of undertakings, multiple companies getting together in some kind of a consortium, or if you happen to be the parent company of multiple companies underneath you, you can have a single DPO for all of those organizations. That's okay to do. But each of the organizations does need to be able to reach that DPO very easily. And finally, they shall be designated on the basis of personal qualities, in particular their expert knowledge of data protection law practices and ability to fulfill the tasks, and the tasks will be defined on the next slide. So this needs to be a person who knows what the law is, and you can't just put somebody into this position who has no understanding of what the requirements are. They need to be able to do this job, but they don't have to be a staff member. You can hire somebody to do this. I'm expecting to see a number of law firms and a number of security companies across the EU and across the world start to provide DPO services to people. So they'll have one person who is heavily versed in and certified in data protection law, and they will start to contract that service out to companies, especially companies that fall into that small and medium business category, who may not be able to afford a person to explicitly focus on this 100% of their time. So the law does allow for that. Now let's talk about the position of the DPO. Now, I said I operate within the information security field, and I have done for quite a long time. The problem that the information security field has had for a long time is that the information security officer, whoever has ultimate responsibility for the information security function within an organization, has often been nested layers down away from management, sometimes all the way under, maybe under the CIO where there's a direct conflict of interest there, maybe even further under the CIO, maybe as part of a function of the networking team. Something like that. And so the person does not have a voice directly to management to be able to get security issues fixed. Well, the GDPR does not allow for that. This person needs to report directly to the highest level of management in that organization. So DPO is reporting to the CEO or to the board. None of this nested 19 layers down. Can't have it. Another requirement. The organization will support the DPO, explicitly listing things that are included in that support, providing necessary resources to do their job, and help maintain his or her expert knowledge. So resources, including money, training, whatever is required in order for that person to keep up to date on what the law requires. And the data subjects must be able to contact the data protection officer. So you and me, customers of a company, need to be able to say, okay, who is the data protection officer for Uber or Google or whoever, and be able to contact that office, that person. Now, the tasks. They need to inform and advise the company on their obligations. So they need to have a method for doing that, which includes being able to train people, being able to know when people are going to make decisions related to privacy and related to security so they can provide the information to them at the moment that security and privacy decision is being made. So being built directly into processes, having reference material in the written processes where those exist, all of that is part of this inform and advise function. They need to be able to monitor compliance for the company. A regulator, so the last one there is that they are the primary point of contact for a regulator. So a regulator needs to be able to call up the DPO and say, hey, Bob, how's compliance with GDPR today? And Bob needs to be able to turn around and say, it's great. Here's the issues that we've seen. Here's what we're doing to fix it. We're on a great path, etc. They need to be able to answer that question semi-immediately. And consequently, they need to be able to monitor what is going on a regular basis. So with all of these things that are part of the requirements for DPO, what kind of person is ideal? It's got to be somebody who's got deep experience in your organization. They know what your organization does and how they do it. A person that has experience with privacy and regulatory frameworks. A person who has the polish and credibility to sit with the board, to sit with the CEO, to sit with regulators and talk competently and constructively about the company's privacy plan, where they're being successful, where they're failing, what they're going to be doing to get things better. A person that is approachable and supportive enough that data subjects, people off the street, can contact that person and talk about issues that they may have, and a person who understands security technology well enough to be able to drive privacy initiatives. So what I'm saying is basically that you're looking for a unicorn. I'm not saying unicorns don't exist. I've found 2 of them in my life personally, but they're really hard to find. So what's likely going to happen is that we're going to find people who have most of the requirements, and we're going to need to shore them up with the things they don't already have. Now, what I'm expecting is that most data protection officers are going to be senior managers, probably people who either worked in legal or who worked in audit. They have regulatory experience, maybe general management, something like that. They'll have most of those qualities. They already know how to deal with the board. They already know regulatory frameworks. They already know the company really well. So that's where our first likely pool of data protection officers is going to be coming from. But the question I have is that person going to have the appropriate knowledge of cybersecurity, of computer and technical elements of security in order to be able to make appropriate directions and strategic plans to support privacy initiatives? So I've always argued that security is you can define security as being the technical means by which privacy is achieved. So this person's going to need to know some elements of cybersecurity, the technical elements, and those are likely going to be those qualities that we're going to need to build from this first round of data protection officers. And this is where the idea of certification and training comes into play, because they're going to have some qualities, they're going to need to get others. And if you have your data protection officer and the staff of the data protection office certified in privacy and data protection, that's a really nice step in ensuring that credibility element. So if you can say my data protection officer and all of my staff are certified in GDPR and certified in information security technologies, that is something that regulators can be expected to look at favorably, assuming that you're actually showing yourself that is you're doing what you say you're doing. So when you're trying to work with the board, with regulators, auditors, media, customers, and the public, and you can make a statement like that, that helps bridge that gap and helps people listen to what you have to say. So EXIN provides a privacy and data protection certification, and it has a number of elements to it. So we have a foundation level where you're learning that fundamental stuff, core elements that anyone that deals with data in your organization should know. So less about the practitioners there and more about that zeitgeist of understanding that people need in order to be able to competently handle data, especially in this new world. But as you progress, we have specialists and certification layers as well, where you need to demonstrate the capability. So there's practical elements to the exam. So somebody not only has the book understanding, but they have the on-the-street understanding of how to apply that information and ensure programs have a greater possibility of success. The exams are vendor neutral, and that practical element is really important. So as a hiring manager, when I'm looking for somebody, I look for certifications that have a practical element to them. If somebody could simply read a book and do the test, that has value. it lets you know that they at least have a baseline level of understanding. But once somebody can actually do it and they've demonstrated that, that provides a significantly higher level of confidence for me as a hiring manager. So one other element of our exams, that recertification is not a requirement for this set of exams. We basically take the approach that when you understand that baseline, you understand the baseline, and maintenance is your responsibility from that point out. So we don't have all of the fees and overhead responsible are required to handle a recertification process, which allows us to offer more competitive pricing. So there we have it. GDPR, some history, and the data protection officer. At this time, I'd like to introduce Simone Venezuelan, who's with me, and she and I together can field questions that you may have about this subject or about EXIN itself. Thank you all very much for your time and attention, and y'all have a good day if you're signing off. If not, I'll be here to answer some questions.
Yeah, so I noted some down there, some questions coming in via chat. The first one is, if I'm based in, let's say, the US or Singapore, and on a regular basis I do business with European companies, do I need to require a DPO, or do I just need to comply with an agency to work on this? What is the solution there?
So it depends on whether you have data about EU citizens. That's the high water mark that you need to be looking at. So if your company processes information about EU citizens and you're collecting any of these kinds of identifiers, and things like name and email address and all that stuff are included on the list. So if you have that about EU citizens, then yes, you're going to need to comply with GDPR. But the second test is, do you have this information, and is that part of your number one? Do you have it for large? Do you have it for a large number of people? And we don't know what that means yet. And is it actually required for you? Because if it's not required as a core part of your business, you might think about, well, I can make my life and my compliance with GDPR a lot easier if I stop collecting it about EU people. And if you just have, if you have a few pieces of information that you need in order to pay some colleagues that you have in Europe, you might think about handling that through a third party instead, and letting them deal with the regulatory compliance elements. It's another business that I expect to see take an upswing. There's already payment processors that reside in various countries and various regions to be able to handle issues like that, so that they can handle the regulatory elements. And all you need to do is say, okay, this is a payment for Joanne, and they will handle all that stuff. I'm expecting to see that kind of business take an upswing in Europe in response to GDPR. So there's a lot of little details there that build into the answer to your question. I hope I've given you the right things to think about.
Thank you. That's clear. You mentioned that it's also possible to outsource a DPO. Is there anything that's clear? Is it based on the number of employees you have as a company, or the number of data, or what is the kind of the
No,
split?
the DPO is allowed to be a third-party person. You know, there's not a limit to that. There may be a business limit to that. So, you know, I'm expecting companies to create a DPO service, and I'm expecting that financial model to be based on the total number of records or the size of your company's revenue or something like that. So once you understand what the licensing model is, there's likely to be choices that you will make that above a certain threshold, it's just going to be less expensive for me to hire my own DPO office than to approach an outsourcer. But below a certain level, it's going to be much more financially feasible for a lot of companies in the small, medium-sized range, especially, to take advantage of those outsource offerings, because you're going to be, you know, there's a host of things that need to be done. And if you could, you know, as far as training, as far as having facilities for people to be able to call in, as far as being able to track privacy issues as you're made aware of them, be able to track them to completion, communicate with the people that put out that particular complaint to you, respond to regulatory requests, et cetera, et cetera, et cetera. There's this huge list of things that data protection officer can be expected to be required to do. And instead of standing up a function to do all that yourself and finding the appropriate person and getting that person the training and standing up the office and doing all that stuff yourself, having a company do it once and figure it out well, and then sell that service to 10 other companies, a dozen other companies, is going to make a lot of financial sense. So there's not limits to it. It's just, there's not regulatory limits to it. It's financial limits.
Okay. There's a very explicit question coming from a partner of ours, a training organization. So they collect data, personal data of candidates. They share that, of course, with EXIN. They get the consent for both parties. Who is in the end responsible for the data?
So it sounds to me, based on this structure, that that partner would be the data controller and EXIN would be the data processor. So both are responsible, by the way. The controller has ultimate responsibility to the end client, but the processor is not off the hook with respect to this. So the definitions, I'm not going to look up the definitions of what controller and processor are, but if you pull the handouts and you look on the slides where I'm listing the articles, there's a link right there that takes you straight to a really nice resource that lays out all the articles in a clean, easy to read format, and it's searchable. So if you go there and just say, define data controller, that should give you the list of your specific responsibilities within GDPR's context.
Okay, great. And then there's a question specifically on the localized languages. So if it's available in local languages, and I can take that one. Right now, the foundation is available in English, French, and Spanish and German. Next quarter, the foundation and the practitioner will be available in Portuguese, Japanese, French, Dutch, German, and Spanish as well. So right now we have the practitioner and the foundation in English only. So that's coming up. This is the end of the webinar. I'd like to thank you all for the attention. You see both of our email addresses there. If you have more questions, and I do see more questions, but we will answer them via email. You will get Quinn's presentation, including the notes and the links, as he mentioned, and this webinar has been recorded. Thank you very much.
Appreciate it.